One of the questions we get online quite often is around common law marriage, and it's no longer on the books in Wisconsin. And so when did it actually get abolished?
So common law just basically gave parties the right to act as though they were married by saying that if you're married for a certain period of time, then we would treat your relationship as though it was a marriage and we'll divide it up as though it was a marriage. It was actually in 1917 when the legislature got rid of common law marriage. It may seem like you are married, but under the law, you're not legally married. You have to file what's called a Watts case, which is a civil action, not a divorce case because you're not married, but you can still go through the courts, through the civil section of the courthouse and file a claim in order to get some of the property that you bought with your partner.
What are some of those protections that might be given to a couple that has been cohabitating for a significant period of time?
Real estate, retirement accounts, bank accounts, anything that the two of you bought together or brought into your relationship. And you can also ask that the court divide up debts. So credit card debts, talk about student loans, any of those things that you guys acquired while you were cohabitating.
Do unmarried couples have rights similar to married couples?
They can address the same types of issues like assets and debts. If you have kids together, unlike a marriage, you'd have to file a paternity action rather than have that hearing and that decided with your civil action if you are unmarried. So it's just, you can have a good amount of rights and protections if you file a civil lawsuit, but it's not guaranteed like going through the divorce process.
Another question that we get from time to time that's along the similar vein is related to inheritance and, unmarried partners and how they may or may not be able to inherit property after the death of their other partner. How might that get adjudicated, or how would the courts work through that issue?
If your unmarried partner dies, the courts will look first to see if there's a will or an estate plan like a trust. And if it does, and your partner had outlined exactly how everything's to be divided up and what you were to receive, then you will easily receive it. If your partner died without having a will or a trust, more than likely you will not be receiving anything because you are not a family member, because they look at the heirs to your partner, blood related, and give those items to those individuals and not non-related family members.
Thank you for watching this video. Please like, subscribe, and share. Your interaction with our content is greatly appreciated. Visit sterlinglawyers.com to learn more about our firm and meet our attorneys.